Calling the October 29th, 2018 Assessment Appeals Board meeting to order. And first things first would be roll call.
Leland Kramer, Chair.
Here.
Mary Ellen Shepherd, Vice Chair.
Here.
Richard Seltzer, Member.
Here. And then do we have agenda amendments?
Proper notice.
I can't hear you.
We need to establish proper notice first.
Oh,
You have your sheet right next to you.
oh, sorry.
That's okay.
I'm looking at the agenda. Okay. Okay. Clerk, would you establish proper notice?
Yes, proper notice has been established. And no amendments to the agenda.
Okay. And confirm agenda amendments, if any?
No amendments to the agenda.
Okay. Sorry, you probably just said that. Okay. Okay. It says Chair announce order of proceedings. You want me to roll through the agenda items? We just finished agenda item 1. This is agenda item 2 is approval of withdrawn applications. Agenda item 3, approval of stipulation in place of appearance and testimony. Agenda item 4, approval of requested continuances and/or postponements. Agenda items 5, conduct assessment appeal protest hearings and presentation of evidence. And 6 is other business.
Okay, agenda item number 2, we have no withdrawal applications.
No withdrawal. Okay. So we move to approval of stipulation in place of appearance and testimony.
And we have one application number 16-054, applicant name Robert Postlethwaite, APN number 145125-10. The stipulated assessment is land, $35,000.
Have a second?
I second.
All those in favor?
Aye.
Aye.
Passes unanimously.
Then we move on to requested continuances or postponements and approval there for.
Move to approve.
That's
Oh, you have to read them?
Yep. 4A, application number 16-034, Dennis J. and Carol A. Thurston. 4B, protest application 16035, Dennis J. and Carol A. Thurston. Application number 16036, applicant name Anchor Bay Campground LLC. APN number 144-022-0900. Protest application number 16-37, applicant name Gualala Properties LLC. APN number 145-261-1200.
Move to approve.
I second.
All those in favor?
Aye.
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 Motion passes unanimously.
Okay, we are ready for specimen appeals, protest hearings, and presentation of evidence. So,
5A, application number 16019, applicant name Rebecca L. Hinsberger, APN number 132-210-4300.
Will all parties and witnesses who are here to testify please come forward and raise your right hand?
Oh, sorry.
That's okay.
Oh, okay.
is Hinsberger present? No? What is the process with that then?
Well, if you don't show up, well, I forget your appeal is denied, I believe. You have to appear.
So that's correct. I mean, it's their duty to either have requested a continuance or to be here to present evidence. If no evidence is presented, then
Is it appropriate to move them to the end of the agenda for protests in case they show up in the interim?
I think that's at the discretion.
Oh,
Well-
okay, 9 o'clock.
Right. I mean, they're right. I'm
The-
sure the council wants to be heard on that.
I actually didn't hear what you said. The assessor would just ask that it would be denied for lack of appearance, but the assessor's office did actually have a conversation with the applicant.
Yeah, I had many conversations with the applicant, and she was willing to withdraw her appeal.
Oh, okay.
Okay.
And since the chair doesn't have that in front of you, then I would go ahead and take this and based on the fact of non-appearance, make your ruling. So
Okay.
Should I make a motion to deny the appeal based on lack of appearance? I make a motion to
Oh, I'm
deny
sorry. I thought
the
you
appeal
did.
based on a lack of appearance.
Second.
For,
All in favor?
Second.
Yeah.
aye.
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 Motion carries unanimously. Protest application 16025, applicant name Douglas C. Gomez, APN number 161250-18. Protest application number 16026, applicant name Douglas C. Gomez, APN 161-25018.
All right, will all parties who are here to testify please come forward and raise your right hand?
You want any witnesses to testify in this
Anyone
case?
who wants to testify?
Cool. And I may indeed testify too, so.
All right, do you solemnly swear that the testimony you're about to give in this matter is the truth?
Yes.
The assessor will be requesting findings of fact on this matter.
I'm out of order in here, so give me just a second. Oh. Sorry. Where was that in your packet?
It's about midway in the packet. So it's right after,
Is it? It's after the postponements, right?
it's right after the one that we didn't hear.
Okay. Sorry, we're getting there, I think. What was the last of the Gomez? Okay. It's the first page of it. Yeah.
It's the one that's typed.
Hmm?
It's the one that's typed. You may have another page.
Okay. Okay, sorry, ready. So presentation is first by whom? The applicant?
Morning. There's several ways to approach this matter. It would seem to me we're talking about 4 different issues here.
Can you speak into the microphone, please? Speak into the, or you can scan to the public.
Well, we can do either one. However, I'm going to call a witness. I'm not exactly sure how you intend to have the witness. Normally we'd have a witness chair or a witness stand of some kind. You want the witness to just come here and testify?
I think they generally come to the
podium.
Okay.
Yeah.
Okay, well, let's, in just a second, we'll do that. First of all, the very first issue we have to address here is the 2-year limitations. Now, I have talked to Mr. Larson, and my name is Dave Schell. I'm the attorney representing the applicant. I've talked to Mr. Larson, and I don't believe he disagrees about the 2-year limitation. That's the first issue. There is a 2-year limitation to bring these matters, for the county to bring these matters before the board and have a decision rendered. That has not been done. This case was filed more than 2 years ago. And I believe Mr. Larson agrees that that is correct, that we are clearly entitled to a reduction in value going back to 2 years, regardless of what happens here. Is that correct, Mr. Larson?
That's my understanding, yes.
So I don't need to go into that in detail unless you want me to. That's the first issue. The second issue then we need to talk about is the general rules pertaining to parent-child exclusion, because that's what this case is about. This is a case where there was a transfer from a mother to a son, and the county is trying to deny the exclusion from reassessment and saying that that was a change of ownership. That was not a change of ownership. We've got to go back here, of course, to Proposition 58, which was on the ballot back in 1986. The voters of California voted and said that a transfer between a parent and child would not result in any reassessment. That was then put into the Constitution, Article 13A of the California Constitution, subsection H1. The terms purchased and change of ownership do not include the purchase or transfer of the principal residence of the transferor, blah, 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 and the purchase or transfer of the first $1 million of the full cash value of all other real property between parents and children, as defined by the legislature. This subdivision applies to both voluntary transfers and transfers resulting from a court order or judicial decree. In this case, we're not talking about the principal residence. We are talking about the $1 million exemption. So that the parent had the right to transfer this particular property to the child without a reassessment. That was later on After it goes into the Constitution, then it becomes chaptered, becomes part of the Revenue and Taxation Code. We're talking about Section 63.1. Notwithstanding any other provision of this chapter, a change in ownership shall not include the following purchases or transfers for which a claim is filed pursuant to this section. And then subsection 2, the transfer of the first $1 million of full cash value of all other real property of an eligible transferor in the case of a purchase or transfer between parents and children. One very important item for you to look at, and I'm not sure if this, we're not in a court here, I'm not sure if you have a way of marking evidence like we would normally in a court. If this was a courtroom, I would ask this to be marked as an exhibit. I'm looking at the Assessor's Handbook, Section 401, published by the California State Board of Equalization. It's entitled Change of Ownership. And the last version that was available prior to the time this case was filed was the reprinted January 2015. So the Assessor's Handbook, California State Board of Equalization. Two different chapters we're concerned about. First of all, Chapter 7, because even though the assessor is telling us to go first in this presentation today, we know what they're going to say, and they're going to say that this is a step transaction, a step transaction doctrine, and that because they're going to apply this doctrine, that we shouldn't be entitled to our exclusion from reassessment. That's going to be their philosophy. Chapter 7 talks about the step transaction doctrine, talks about how it focuses on what really occurred after all the steps in a transaction are completed. They are going to say that because in this case the property was transferred first to one son named Ralph, and then later on Ralph transferred it back to his mother, and his mother gave it to another son, Doug, that we need to treat it the same as if it was a transaction between two brothers. Well, that's a bunch of nonsense, and I'll show why in a lot of reasons, but I just want to address that right now while I'm talking, and I've got the floor. Chapter 7 of this Assessor's Handbook talks about the step transaction. And let me point out, first of all, that you can't take a step transaction and say, we're just going to start in the middle. And that's what the assessor is trying to do. In this case, the property started out with the mother. And I keep saying mother here. Originally, it was mother and dad. But dad died along the way, and mother inherited everything from dad. So I can use the two terms interchangeably, parents or mother. In this case, it's really mother all the way through. You got to start at the beginning if you're going to talk about a step transaction. And the beginning is mom bought the property. Mom paid for the property. Mom gave the property, deeded it to a son, for estate planning purposes. Later on, for estate planning purposes, the mom changes her mind, as she is certainly entitled to do. She says, give me that property back. I want to do something different. Son gives it back to her, and she gives it later on to another son. That's perfectly appropriate. And if you want to collapse the steps, which is what the step transaction is all about, you got to focus on what really occurred the entire time. It was mom's property, and it ends up in a son's name. That is a transfer between a parent and a child, and that is exempt from reassessment. That is not classified as a change of ownership. Not that the step transaction really applies here anyway, because as we will see, it really doesn't. But I'm just addressing that issue at the beginning, so there's no misunderstandings. If you go at the end of Chapter 7 of the Assessor's Handbook, it says, see Chapter 12 for a discussion of the parent-child and grandchild exemptions, exclusions. And you look over at Chapter 12 of this handbook.
Counsel, sorry, if you could refer me, since I've got it in front of me, the pages that you're on, and that way I can hopefully advise my board.
Certainly. The first thing was Chapter 7, and I was talking about page 54, and then 56. 56 says, see Chapter 12 for a discussion of the parent-child exclusion. When we look at Chapter 12, we're going to look over at page 86. The parent-child or grandparent-grandchild exclusion provides that a change of ownership does not include the transfer of a principal residence and the first $1 million of cash value of other real property. And then continuing on to page 87, a qualifying parent-child transfer can be in either direction, from the parent to the child or from the child to the parent. These exclusions apply to both voluntary purchases and transfers or involuntary transfers resulting from a court order or judicial decree or by operation of law. Thus, most transfers of real property between eligible transferors and transferees that occur after the respective operative dates can qualify for the exclusion. Then you skip over to page 91. At the bottom of page 91, in enacting section 63.1, the legislature stated its intent that the step transaction doctrine should not be applied to collapsed steps involving parent-child transfers, including transfers involving legal entities. In an uncodified note to section 63.1, the legislature wrote in part that, quote, "It is the intent of the legislature that the provisions of section 63.1 of the Revenue and Taxation Code shall be liberally construed in order to carry out the intent of Proposition 58 on the November 4, 1986 general election ballot, to exclude from change in ownership purchases or transfers between parents and their children described therein." And then skipping down, thus the step transaction doctrine should not be applied where transactions are consistent with this statement of legislative intent. It's on page 92. There's also a general letter from the State Board of Equalization dated February 29, 2008. It's an all-county letter, number 2008/018, talks about the Revenue and Taxation Code sections and parent and child exclusions, gives again the same history, says basically the same thing. Any transfer of real property between a parent and a child is exempt. And if we go over to that letter, at the end of the letter, the February 29, 2008 letter, it says, enclosed is a series of frequently asked questions and answers. So there's these questions and answers that are attached to this all-county letter. And page 6 of the questions talks about the fact that even if there's a legal entity involved, if it's going between a parent and a child, that still covers under the exemption. Page 7, does the step transaction doctrine apply to legal entity transfers? Answer, no, it does not. Page 8, if a parent who owns real property dies and his child inherits the property, does that transfer qualify for the exclusion? Yes. The mode of transfer is not an issue. Any transfer of real property between parents and children are eligible for the parent-child exclusion. And it also addresses the step transaction again in the same way over on page 22 and says basically the same thing.
Mr. Schell, I just want to, perhaps we can let you know, I think the total time that your side has for presentation, if I could check with the clerk, is how long?
20 minutes.
We were never told 20 minutes before. It doesn't say that in any of your papers that you have provided to us. I will try to keep it short and simple, but there is no such thing in any papers that you've given us. At any rate, my intent would then be to call a witness to testify to some of these things. I would call Ralph Gomez.
Right behind me.
Right behind me, okay. So, Ralph, are you one of the sons of Mary Gomez?
That's correct.
And you're...
I'm sorry, one of you will have to speak into another microphone.
That's correct. We'll share it. Or I'll just talk loud. I won't even need a mic.
Yeah, no, just because it's being recorded, thank you.
That's fine.
Okay, you're familiar with the property at 2360 Road E in Redwood Valley?
Correct.
You know your parents bought that property around 1980?
Correct.
And at that time it was a bare lot?
That's correct.
Do you know who paid for it?
They did.
Okay. Later on they subdivided it?
That's true.
And who paid for the subdivision?
They did.
And later on they built a house on it?
That's true.
And who paid for that house?
They did.
Did you pay any part of the money for any of those things?
Not at all.
Okay. I'm going to show you here a deed. Let's see here. Showing you a deed dated December 18, 1986, from Ralph Gomez and Mary M. Gomez. And it's to them as to a 1/3 interest, to you as to a 1/3 interest, and to your brother Doug as to a 1/3 interest.
That's true.
And by the way, for the record, so there's no misunderstandings, your father was also named Ralph, is that correct?
That's correct.
Okay, and your father has subsequently passed away?
Oh, yes.
Okay, so at the time this deed was made out, 1986, did you ever see this deed?
No,
Did you ever see this deed until I showed it to you a few days ago?
just when you showed it to me.
Okay.
Yeah.
And subsequently, there was a deed dated August 12, 2002, recorded 2002-18180. A deed from Ralph and Mary Gomez to you and your brother Doug as to 1/2 interest in this property.
Mm-hmm, that's correct.
Had you ever seen this deed before?
No, never did.
Did you even know about it until I showed it to you
No,
recently?
that's the only time I saw it, Dave,
Okay.
was when you re-educated me on it.
Okay. Subsequently, did your mother come to you and ask you to sign a deed to her?
Yes,
Okay. And at that point in time, did you even know before she asked you that you owned this property?
no,
Okay. And so in 2014, you signed a deed recorded, recorded as document 10145 in 2014?
correct.
Okay. Dated August 6, 2014. You signed that deed?
Yes,
Did you pay any, did you get any money or any consideration for signing this deed?
no money at all.
You just did it because she asked you to?
That's correct.
Okay. And did you have any understanding at that point that she had, in fact, she told you that she had set it up that way for estate planning or something to that
She
effect?
set it up exactly for that
Okay.
exact reasons.
Okay. Did you ever pay any taxes on this property?
No, I
Did you ever
never
pay
did.
any insurance on this property?
Never did.
Okay. And subsequently, your mother passed away?
Oh, yes.
And showing you a copy of a death certificate. This is a copy of her death certificate. She died on January 11th, 2015?
Yes.
Okay. No further questions with this witness? Yes, you can sit down.
Thank you.
So, I would also offer my own testimony. Since I did do the deed for 1/2 to each of the boys, and I later on did the deed from Ralph back to his mother, and I later on did the deed from the mother to the other son, Doug. And my testimony is very simple, and that is, this deed was done for estate planning purposes. That is the whole point in this. And the mother was entitled to change her mind and do things differently. There's no to say that she wasn't is crazy. I mean, she died just a few months after that last deed was made. True, she could have just as easily made it as part of her will or her trust, and there might have even been some advantages to that. But it doesn't make any difference. We come out the same, whether the son Doug receives it as part of a court inheritance after a will, or receives it through a trust, or receives it now in his lifetime. There is nothing that prevents the mother from having the right to do that. It is not a change of ownership, and the son who received ultimately received the interest is entitled to retain it, and he's entitled. It's not a change of ownership. He's entitled to keep the same tax rate as before. Thank you.
I'd like to submit some information to pass around. I don't know who passes this out. My name is Dirk Larson, Chief Appraiser with the Assessor's Office. So I do think it's important to start at the beginning here. And, you know, there's been reference to a couple recorded deeds, and I'd like to start when they first purchased the property in 1980. Ralph Sr. and Mary bought the property in 1980 together as husband and wife. 6 years later, Ralph and Mary gifted a 2/3 interest to their boys. So title was held as Ralph Sr. and Mary owning a third, and each boy owning a third. Then 16 years later, in 2002, the mother relinquishes entire interest in the property. And the boys now own 50-50 in this property that we're talking about. So 12 years expire, and then all of a sudden in 2014, within a week, Mom comes back on title and then transfers the 50% from one boy to the other boy. So what we're arguing, it definitely is a step doctrine transaction here. And what you have to look at is the overall scope and picture and what the intent is. And we believe that you collapse those steps, and the intent all along was to transfer the 50% interest from one son and one brother to the other brother. But they wanted to circumvent the property tax law and avoid any increase in property tax. That is the heart of our argument. I've also submitted, with that information I've handed you, an opinion from the State Board of Equalization that's agreeing with our decision. And that what Mr. Schell has referred to really deals with business entities when we're talking about this parent-to-child exclusion situation. So that's pretty much it. And then there was also a question from Mr. Schell about how we were picking and choosing what we wanted to defend our case, and that just wasn't accurate. I provided him with the full email exchange that we did have with the state to show that there wasn't anything other than stating the facts and getting their opinion without trying to push their decision or direction in our favor. So that's pretty much it. And I think it's important that the step transaction doctrine does apply here, because we applied the end result test. And what that says, in essence, there's a series of deeds recorded which appear to be intended from the beginning to reach an end result of transferring Ralph Jr.'s interest to his brother Douglas. And again, as I stated earlier, to circumvent the property tax law and avoid that increase in property tax. So that's pretty much it in a nutshell.
I have several items that I need to address in response to these comments. First of all, I would object strenuously to the introduction of this Exhibit C of these documents that the assessor has just provided. That is not relevant. It is hearsay and it's at its worst. We have a statement here, email statements from somebody at the Board of Equalization that are totally wrong, that I don't have the opportunity to personally...
So if I could, I'm going to look to the chair in terms of conducting this hearing. I believe, I'll look to the clerk to correct me if I'm wrong, but again, there's a certain time period allowed to the applicant. Again, you need to be conducting the hearing as we go through this.
The rules clearly provide that the applicant is entitled to have a rebuttal to whatever evidence is presented.
So I'm looking to the clerk for our own, once they've used up their full time, do they reserve time for rebuttal? Okay, so you have 3 minutes. I'm just trying to give you information because you were complaining.
That's fine. I appreciate that. However, you do need to address these things in advance. And the papers that you provided us with said that we would have as much time as needed to present our case, and that has not been done. But I do object to this Exhibit C. I realize this isn't a court. If it was a court, I would certainly, object and ask the judge to not allow Exhibit C to come in, because we haven't had the opportunity to question the people about this. And it's a completely wrong, misleading statement. What counts is the manual. We've talked about that before. And the official documents from the assessor and the state law, the Revenue and Taxation Code and the Constitution. Number one, a parent-child transfer is excluded from reassessment, period. That is what Proposition 58 said. That is what the Constitution says. That is what Revenue and Taxation Code says. The step transaction doctrine is something that's come in to try to, it didn't even originate with parent-children transfers. It originated back with income tax laws back in the federal government, but it's been applied and allowed in assessor transactions in other cases, but not for parent-child exclusions. Parent-child exclusion applies, period. And even if, as I said earlier, even if you wanted to try to apply a step transaction doctrine, which is not applicable, you need to go back and look at the whole transaction. This is property that belonged to the mother. She put the child's name on it. The child didn't even know his name was on it for estate planning purposes. She took his name off, and then she made a different disposition with it. No matter how you look at it, it's a transfer from a parent to a child. It is not a change of ownership, and that child is entitled to the benefit of exclusion from reassessment, period.
Well, I think it's pretty incredible that, so, you know, if we look at it as a whole, as Mr. Schell argues here, the property was, through estate planning purposes, in our opinion, transferred to the boys as it was intended. But then a period of time goes by, and all of a sudden the mom comes back on for a week to obtain the 50% interest that she gifted 12 years later, and then turns around a week later and gives it to the other son. I think it is important to apply the doctrine here because it is pretty specific. And I'd like to read you this here that you guys all have in front of you. The general principle is that whether a transaction is a change in ownership depends upon the substance of the transaction rather than its form. That is, the doctrine focuses on whether each step of the transaction may stand alone, or rather, whether the transaction should be treated as a whole. And this kind of gets down to, and again, our end result test. It is pretty apparent to us that the idea was to, and if we collapse these steps, were the extra steps of bringing mom on title for 1 week and then transferring to the other son necessary, when we believe the intention was to transfer the brother's 50% to the other brother. And under California law, that is a change in ownership.
In equity, this was always the mother's property. That's the point I'm trying to make. Mom paid for it, mom owned it, son had no interest in it, it's mom's property. You know, just the form of a deed is not conclusive. The evidence code says that it certainly can be rebutted who owns a piece of property. And if you had, in a case like this, if there was some dispute between the child and the mother, and had gone to court over it, mom would have been able to get her property back. She put her son's name on it, he didn't know about it, he didn't pay anything for it, he doesn't have any interest in it, it's her property. It's always been her property. In equity, it is hers. In equity is hers, and she is entitled to leave it where she wants to leave it. And she can change her mind. People have that right.
So it is an equity. You know, I do agree with that, but I think it's pretty evident that the parents, and let's keep in mind that they gifted this property to their kids, which happens often, parent to child. Parents often leave their kids, gift their kids property, equity, etc. So in this case, I think it's pretty clear based on the deed recorded in 2002 that Mary and Ralph Sr. forever quitclaimed and gave up interest in this property to their boys, which they probably intended to do, as you state. And then, you know, it's curious that 12 years later, all of a sudden, mom's changing her mind for 1 week and taking back half of the property from just one son and then giving it to the other son. I think, I do agree, you have to look at this case on the whole and what's occurred from the first time they came on title, the parents, and what happened up to 2014.
I assume that I don't need to introduce this assessor's handbook, since county council already has a copy of it, that you can look at it if you need to. If not, I would offer it into evidence.
I think we're going to have to look at that, so if he has the specific pages.
Yeah, I would only want to make sure that it hasn't been updated since the one that you have.
Well, keep in mind that there's been over 2 years since we filed this case.
I know, that I just want to make sure we're looking at a relevant one.
Right.
I don't know what it is.
What does your copy say on the front? Does it say up?
So the thing that I have does not appear to be the thing that you have, so let me see what it is. So he's basically trying to introduce into evidence handbooks, which has the law. So I think in terms of referring to the law, he refers to the law, you have the law. If you want to accept that to review, I that's up to the chair.
Yeah, I think we can accept it to review, because if what the law was 2 years ago is the relevancy at this point, is it not?
Correct, the law at the
Yeah.
time. I don't think, I'm not aware of any change in this law.
Yeah.
But
Yeah, I don't think there's been any changes either that I'm aware of, but I don't, more recently.
Okay.
I have 3 questions, I don't know.
Yes, we have questions, and do you have questions?
I'll wait for Dick to
Go ahead.
ask his.
Maybe we make one more point. The appellant mentioned the use of hearsay, and hearsay is permissible under an assessment appeals board hearing. And I have a case citation and a code of regulations citation if the board needs that.
Okay. I have 3 questions. First one, was the division of the estate 50-50 between the 2 sons? And was the value of this property allocated, the value of the equity in this property, did that come into play in determining the 50-50 balance?
So I would suggest that if the board's going to ask questions, you make sure you say who you're asking the question of.
Sorry.
Just to keep
Mr.
some
Schell.
order in this.
Do you know if the estate was divided 50-50 between the 2?
It was divided generally in half, but not exactly, no. It was not exactly in half.
Okay. Was the value of this property used in determining the balance of the distribution?
I would have to say that probably it was.
Okay.
Although but again, only generally speaking. I mean,
Okay.
she had 2 sons, and she's trying to treat them fairly. They had different pieces of real property, both here and in another county. You can't put an exact value in any
I
of these
understand.
things. You know, we're just trying to.
My second question, what was the total value of the estate?
Impossible question. I don't think.
Was it in excess of $5 million?
No, no.
So there was no estate tax
No
due?
estate tax. No, definitely not $5 million.
And the last issue is, had mom passed away prior to this most recent 2 deeds, the one from son to mom and mom to other son?
No.
If she had passed away prior to doing that, who would have ended up owning the property?
Oh, if she'd passed away previous?
Yes.
Uh,
Would it have been 50-50 between the 2 sons?
I believe it would have been. I believe it would have been. But she did make changes to her trust and her will at this same time, these 4 or 5 months before she died. We're talking 4 or 5 months before she passed away. She'd made various changes, and doing things differently, what she wanted to set up her estate.
Thank you.
I have no questions.
Nora? We declare the hearing portion closed, and we will go into private session. 10:25. I'm calling the Appeals Board hearing back to order. No, my light was off. And we have found for the appellant, primarily on the basis of the 2-year period, and secondarily, we believe it was a parent-child transfer and qualified.
Thank you.
That's it.
Invite the motion to accept.
Oh, move to accept the action.
I second.
All in
Motion,
favor?
Aye.
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 motion carries
Oh, I'm sorry.
unanimously. Moving on, motion or application number 16031, applicant Land Bank Properties, number 3LP, APN 008-154-2700. Application number 16032, applicant name Land Bank Properties, LP3, APN 008-154-2500. Application number 16033, applicant name Land Bank Properties, LP3, APN number 008-154-2600.
Move to deny the application.
I second.
All in favor?
Aye.
Aye.
Motion carries unanimously. Moving to application number 16061, applicant name Gard B. Cookson and Whitney J. GTE, APN number 049-380-3800.
Will all parties and witnesses who are here to testify, please come forward and raise your right hand.
She's not going to testify to you.
No, if she's not gonna speak, she doesn't need to. You can watch.
Alright.
Do you solemnly swear to tell the truth? Sorry, wrong one. Do you solemnly swear that the testimony you are about to give in this matter is the truth, but the truth will help you back?
I do.
The assessor shall be requesting findings of fact on this matter as well. Thank you.
So, and just to remind the chair, usually a request for findings of fact is supposed to be in writing. So I'll leave it up to the chair's discretion.
Who made the request? Yeah, I got that. Thank you.
Am I supposed to be talking? First of all, the screen doesn't seem to be lit.
Okay.
Oh, okay.
Pardon me? Can I get his name?
Yes, and which side? I'll go first.
Oh, right.
I can barely hear you, I'm sorry.
You'll have to request or announce which side you'll hear first. The applicant
Okay.
or the assessor.
Okay, typically it's the applicant.
Okay.
Okay. We will hear the applicant first. Would you identify yourself, please?
I'm Gard Cookson.
Okay.
All right. So,
So just to assist with the chair, so I think what's being requested here is to present evidence through a PowerPoint. So
Has the assessor seen the PowerPoint?
No, we have not. The only thing we've been provided is an appraisal report, and that's what we've based much of our argument on.
And I'm highlighting the appraisal report. I just thought it would be easier to show it on a screen.
Are you, assessor, okay with that?
Yeah, if it just sticks to the report, I'm fine with that.
Yeah.
Yeah.
Okay. And I have a printout as well that I can give
Could we have
later.
a copy?
Sure. If I can give that to you perhaps afterwards, so you're not flipping through it. And I'm happy to give it to you afterwards.
I would
or
actually
after
like
I've
to
done
receive
it.
it now.
So, and
You'd like
you,
it now?
Yes, please.
if you have a printout and you're presenting, usually you would give that to the clerk to provide to the.
Okay. I've got 4 copies. So
Let's give 3 to them and 1 to them.
That's fine. Thank you.
To the clerk, please.
To the clerk, to the clerk.
Might have a bomb in it.
Thank you.
Then you get blown up.
Okay. We ready?
Yes, please.
Okay. So, first of all, kind of like the last applicant, a decent amount of time has transpired since filing this application and getting to this point. And that has actually brought some new evidence to light, and as well as brought closure to one of the issues at hand. So that actually helps hopefully clarify this whole situation. So we're looking to lower the base value set at the change of ownership on July 28th, 2014, just so that we're clear in terms of what we're trying to do, which is when we purchased the home and property. Okay. So there are 2 factors that come into play here. The first is fraud and misrepresentation of the property. Some serious stuff. The next is that there were some serious errors made by the appraisal that overvalued the property. So the first thing that I'm going to get into is the fraud and misrepresentation of the property. Right here, what I've got is one of the many brochures that were presented for the property. This was also available online in terms of describing the property. And what I've highlighted here are the 5 acres under contract planted in Syrah and 1 acre of Primitivo. So a total of 6 acres of vineyard. Okay, so here we have the tree vine report that was actually, and somewhat ironically, submitted to the county tax assessors from the previous owners. And you can see here the block acres equal a total of 2.8 acres. Less than half the acreage that's been advertised. So
As planted.
As planted, exactly. So in terms of the misrepresentation, and also the California Agriculture also had a similar report from the previous owners as well, specifying the 2.8 acres. So it was with full knowledge that they were misrepresenting this property solely to increase and inflate the price of the property. So despite our best efforts to communicate with the previous owners and come to some sort of an agreement, we ended up having to sue them. And we settled with the previous owners for $120,000. We ended up not going to court, so we settled out of court before our July date of this year. So that's one of the things that we brought to closure.
Okay.
Okay. So I think that the $120,000 is a fairly accurate amount in terms of the missing vineyard that reduces the property value. And that's one of the aspects that we're looking at to reduce our taxable value at the time that we purchased the property. Now, with that said, the assessor is going to tell us that the vineyard had no value. And they're going to rely on the appraisal, which I provided to them. And the reason that they're going to say that the vineyard had no value is that the appraisal looked at, and we're going to talk about this a little bit, the appraisal looked at a number of different ways that they appraised the property. There was the cost approach, an income approach, and also they also did the kind of more standard comp sales approach. But the most amount of weight that they put was on the income approach. And the reason that they did that is when we purchased this property, we purchased it to create a business for a bed and breakfast and for a venue. Okay, there was no business there before. So they felt that the income approach was most justifiable. Okay, so, and an income approach, I'm sure that you're in real estate and are familiar with an income approach, looks at businesses in the area. They ask them, how much money do you make? What is your occupancy rate for the year? And from that, then they apply those numbers and say, well, how much money could this property make? And from that, using what's called a gross multiplier and all these calculations, they come up with a price for the property. To be honest, I think it's a little bit of voodoo, but at any rate, that's one method that they used. They specified the cost basis, and they used the income approach. Those were the two that they added the most weight to. Now, in terms of the appraisal errors, they made two different errors. One is that they made up square footage that never existed. Number two, they miscategorized square footage. So we talked about a little bit about that there's in this appraisal, there's the cost approach, the income approach, and that sales comp approach. All three methods came to justify the appraisal for the property. Okay, so what I want to make sure is clear, the cost approach and the income approach. The income approach relies on the cost approach. Okay, and why is that? Okay, let's say that you took a barn and you added 20% of extra square footage to it. Well, that's 20% in error. That's 20% more room that we could rent out. That's 20% more that we might be able to get for that venue. So that directly relates to the income. Let's say that the square footage of the bed and breakfast was miscategorized from uninhabitable space. They actually categorized it as habitable space. Obviously, that's potential income producing square footage. All right, so income approach and cost approach are tied together. Okay, so as there are errors in terms of this appraisal for the square footage, we need to figure out the value of what the square footage is. Okay, and the appraisal creates that cost per square foot. So we're going to look at the actual appraisal here. Here's a page from the appraisal. This is the cost approach. So if you look here, you can see they have area and cost per square foot. So basic structure, they've got $115 per square foot. Attached garage, $50 a square foot, and the barn, $50 a square foot. Okay, that's not the whole picture though. If you look down a little bit further, you'll notice that there's other multipliers. I don't think anybody can build anything for $115 a square foot, right? Okay, so that's like a base fee, and then they go, okay, there's other current costs and location and other factors, and all of that adds up to 151% added to these base numbers. So if we look at this, we had the $115 per square foot, we add 151% and we get $173.65 per square foot. Same thing with the $50 per square foot, you add the 151%, $75.50. Does this all make sense so far? I don't want to jump too quickly. Okay. So now we have a cost per square foot. So the first issue, they made up square footage that never existed. This is the barn, the ag barn that was on the property. And you can see it's highlighted there. It says it's 2,400 square feet. It's not 2,400 square feet. Here's the original permit for the barn. It's 2,000 square feet. Here's the original plans for the barn, 40 feet by 50 feet. It's 2,000 square feet. So the barn was entered as 2,400 square feet. It's actually 2,000 square feet. That's a 20% difference in terms, and 400 square feet. So what's that value of the square footage? Well, we've done our calculations. So we do 400 square feet times $75.50. $30,200. Okay, so the next issue, second issue, is that the basement footage is included with higher value living area. So in order to understand this, the house is 3 levels. Okay, there's the main level, there's the upper level, and then there's the basement level that includes 800 square foot of a garage.
So are you saying the 1,625 square feet in the basement, that 800 square feet of that is actually a garage?
No, it's in addition to it is the, so it's 1,625 plus 800.
Okay.
Yes, so about 2,400 is the total basement.
And is the basement finished in a like manner to the rest of the house?
I will show you.
Okay.
So here I actually pulled up the plans. I highlighted in yellow the basement. You can actually see that in the lower corner, and sorry that's very small, it says 1,625 square feet is basement. The green area is the garage, all the same level. Okay. And to answer your question, this is the basement.
That's the basement? Okay.
Okay. So, unfinished, unconditioned, no heating, no air, concrete floor. Okay, so let's go back to this cost approach. You notice how it says basic structure and tenant improvements are over 7,300 square feet?
Yes.
So again, I'll pull up the breakdowns. 3,900 square feet for the upper level, the main level. There's the upper level, the basement. Well, where's the basement called out? It's part of the basements of the basic structure. It's included with a higher value living area. So again, we go back here and we say, so the appraiser included that 1,625 square feet of unfinished, non-conditioned, no heat, no air basement with the entire house. So to get the calculation, we subtract the value that the appraiser calculated at the higher rate times the 1,625. So this is the calculation, $1,625 times that $173.50. We get $282,000 approximately. The correct value at a basement square footage of 7,550 is 122,000, almost 123. And the difference is $159,000, almost $160,000. So again, if you look at the income approach and you say, okay, you've got a bed and breakfast that is missing 1,625 square feet, obviously that's a potential for income producing, and it isn't going to be income producing. So I think that the value here is significant. So the factors for reducing the taxable value are the fraud and the misrepresentation of $120,000, the 400 square feet of erroneous barn area, $30,200, and the basement square footage miscalculation, which is about $160,000. So the total reduction of value is $309,694. And I still have 6 minutes to go.
Do you have any comparable sales, improved comparable sales to support your opinion as to reduction in market and assessed value?
So the way that the appraisal, this was, first of all, this was a 126-page appraisal, okay? Very, very detailed. They actually did a sales comp as an addendum at the very, I think it was the very last page of the appraisal. So they kind of, because this is a rural property, very difficult to find comps that can match. But I think that the cost approach gives us accurate square footage costs and values to the property.
Okay.
Did that answer your question?
The answer was no. You don't have any comparables.
Okay.
Is that correct?
I do not, other than what is in the appraisal.
Okay. Is that the final page?
That is not in this PowerPoint
So it's not in the
presentation.
document. Okay.
Correct. Oh, just one last thing. I do have a copy of the check, or the checks actually, from the Realtor and the previous owners in terms of the payment that was made for the fraud.
Okay.
I just didn't think I should put that up on the screen.
You mentioned checks from both the seller as well as the Realtor, so there was a settlement from both?
Correct. Yes.
Was the property operating as a bed and breakfast when you purchased it?
It was a hobby, so they had no income to show for it.
I see. Okay. So it appears that your opinion of value on your applicant opinion is significantly different than the assessor's opinion. The assessor's opinion is shown as $2,195,500, and yours is shown as $1,381,936.
From my original application?
I'm not sure. I see value on roll, and then I see applicant's opinion of value.
Yeah, I think that again, 2 years has actually transpired since doing that application, and that's why I said that new information has come to light, and then the closure in terms of the lawsuit. You know, I had to make some estimates in terms of value of the lawsuit, so this is more of the hard numbers, the realities.
So your actual request is to lower it by 309, not by 800?
Correct, and I apologize for not making that clear.
I see. Okay.
I'm sorry.
That's
for
all right.
not clarifying that.
Where did you get the $75.50 per square foot value for the basement?
Sure. So basements and garages are calculated at the same rate. So since there is both basements and barn that were calculated at the $50 per square foot, that then gets multiplied times the 151%, that's where I got that number.
Say additional information came to light. What was that additional information?
Actually, it was that the barn was, and came to light in my own head, I guess would probably be the better way to describe it, because I didn't catch initially that the barn was over footaged, whatever the statement is. That it was actually 2,000 square feet, not 2,400 square feet that they put in the appraisal.
But that would have gone the other direction. So we're talking about a $500,000 difference between your original request and your current request. Where did that $500,000 go?
Oh, I'm not somebody who's was or probably is well versed at appraisals and how calculations are made. And one of the things that I had noticed in the income approach was when they do income approach, they are looking at income and they also take out costs. And one thing that I had noticed that they hadn't taken out was mortgage interest, which is a significant cost. So I, in my original submission or application, put mortgage interest as I thought that that was an error in the appraisal, and that actually is not. So that's one of the issues.
I miss it. What is the sales price of the property?
The sales price was 2.175.
And so you're asking for an assessment of $1,865,306?
Correct.
Is that before or after the homeowner's exemption?
I don't have that number in front of me, so.
There's a 7,000 homeowner's exemption.
Yeah, I mean, if that's their primary residence, they'd be entitled to that.
Yeah, I'm not complaining about that. I just, the bottom number of 2,196,500 includes that exemption.
It's before the homeowner's exemption.
It's before the homeowner's exemption.
And I can explain some of that when you're done questioning the appellant.
Now, when you significantly reduced your land value, was that based on the change in planted area?
When you're talking about the 120,000.
So on the roll, assessment for land is $859,917.
Mm-hmm.
And then in your applicant's opinion of value, which, should I just disregard all of those numbers?
I would disregard
Okay.
it.
All right. Great. So are you going to ask us to rule on the same percentage of value land versus compared to total that the assessor has currently? So currently, let's see, based on the roll, they have the land value at about 39% of the total.
Yeah, I think that whatever the new value is, the same values would
Okay.
apply.
Right.
Okay, thank you. I'd like to submit some info for all of you to look at, and what I've provided is a full copy of the appraisal report. Here you go. So I'd first like to say it's unfortunate because it's apparent the owner,
Are you?
I'm totally fine. I just tripped. No problem.
catch my breath. So it's apparent that the owner was misled on this property. Oh, Dirk Larson, Chief Appraiser, Assessor's Office. So the owner spends a lot of time relying on this appraisal report when he's talking about value. I think it's important to point out that this report was made primarily as the renovated going concern. Like, this would be the value if you were to convert the barn and all these other issues and part of the basement to a 5-bedroom B&B, which it was not. And we're going to go through the report. And the owner and the seller both agreed there was no income derived from any B&B business at this property. It was simply a hobby. To the vineyard, the last report we received from the owner was based on 4 acres from the owner, the prior owner's report. So that's what we had on record, and I believe based on correspondence, and I'm coming into this later, the appraiser and the owner had conversation, and the appraiser agreed that he would drop the vineyard to 2.8 acres from 4, which was reported from the previous owner. So we just went with the best information that we had received prior to that. So, you know, the owner in his argument here is talking about the cost approach and the inaccuracies in the appraisal report done by their appraiser and the square footages. We don't have that. we don't have 7,000 square foot of residence. In fact, when we do our cost approach on file, we show the basement area to be 1625 with the garage of 760, very similar to what he has quoted here, and the residence itself at about 5,700 square feet. Now, this cost approach sheet that he's utilizing in his argument is based on a projection and renovation to a 5-bedroom B&B. So, and then if we look at that cost approach sheet, which I can show you is between page 27 and 28, they're projecting the property value would be $2.3 million. Now, we inputted what he paid for the property and what he reported on his preliminary change in ownership report. We did nothing more than that. We inputted 2.175, but of that purchase price, he reported that $25,000 represented personal property. So we backed that out, and his assessment was based on that difference, 2.15. So we just inputted or assessed him at what he paid for the property. I think, you know, again, based on my review of correspondence with our office in the past, you know, he was having an issue with the misrepresentation, and again, I can appreciate that frustration because you know what I've included for you guys is the listing, and I think he provided one too that shows 5 acres under contract, 1 acre, you know, so 5 more planted acres. That's inaccurate. We never had that either. But as we work through the report, and I'd like you guys to refer to that now, well, just first off, I want you to see the first cover letter. It talks about how the appraiser is just providing this report as if renovated, as if you were going to make these changes. This is kind of what the income approach would be based on. It has no bearing what he paid for it, and that'll be proven as we move through this report. So first, let's change to page 4. And at the very top, they both agree that from the client, the appraisers do not include valuation of the subject's vineyard contribution to value. The vineyard is considered a hobby vineyard with revenue offset by production expenses. We consider the existing vineyard to be an amenity for the subject's grounds, enhancing available views and ambiance. Nothing more than that. There's no income potential there. If we now move to page 7, I want to define what they define as is market value, the estimate of the market value of the real property and its current physical condition, use, and zoning as of the appraisal's effective date. This appraisal was done a month or so before they actually closed the deal. And I think it's important to point that out. Again, a lot of these cost approach and income approach values that they come up with are projections. If renovated, this is what the value would be. So if we move on to page 15 in the report, down at the bottom, our conclusion of fee simple as is market value of the going concern contained herein is equivalent to and correlates well with the purchase price that they agreed on, $2.175 million. So if we move on to page 27, what we're looking at here is what the report has indicated the square footage of the home to be. I want to point out for the record that on our records, we have 2,000 square feet representing the barn. We have 400 square foot storage building. And we have, as I stated earlier, the residence being at about 5,700 square feet. We are absolutely breaking out an unfinished, unconditioned basement area in our valuation. If we then turn to page 29, again, I just want to highlight there's a mention of 4 acres at the landscaping area, 4 acres of grapevines in the report. They listed it at 6. I mean, to me, these guys had a chance to review this report, before, in, and at conclusion of the transaction. I think it's also important to note, again, at the bottom, appraisal does not include any contributing value for the vineyard other than the site amenity for the subject facility. If we move forward to page 33, under conclusion of highest and best use as if vacant, it is also, at the last sentence, it is also interesting to note that a business value is not allocated by the buyer and seller. We also determined that the subject will not produce sufficient income to produce a business value, assuming our revenue production estimates for the subject. So they're already concluding that as is, the agreement they've reached at $2.175 million does not include any income for a B&B or a vineyard for that matter. If we move forward to page 36, second paragraph, last sentence. This analysis is included in the addenda section and demonstrates that the real estate value of the subject, as if valued as a single-family residence, is equivalent to the as-is going concern value, which, as we've been pointed out, this is more or less a hobby property. Now we move to page 56. The fee simple market value of the going concern, at the bottom 2.175, it's, it matches what they were agreeing on and what they closed the deal for. The middle paragraph, however, as demonstrated in the addenda section, the subject has an intrinsic value as a residence due to the size of the home. Therefore, a buyer of the subject would live and use the subject as a personal residence and not base their purchase of the subject solely on income potential. As a result, we conclude that a typical buyer would not expect any discount for stabilization and would instead immediately utilize the subject as a personal residence while any renovations were completed. And again, as I stated earlier, much of this report is based on a projection, and if renovated, this is the income potential. If we then turn to page 57, it talks about the summary of value conclusions. They're giving you, this prospective value, I think on the cost approach where he was breaking down the square footages and removing value, that was based on if renovated. And they came up with a figure of 2.3 million based on that cost approach figure. And then lastly, if we just turn to the last addendum H, the very last page of the report, the appraiser does provide a sales comparison analysis. And these sales that he included, although, I agree they were hard, few and far between, this is a unique property, it was agreed based on, that analysis that what they were paying for the property, what they reported was the actual market value in its current as-is condition. And so just to conclude, we just appraised it at what they reported to have paid for the property. But I think we have agreed that we definitely can make an adjustment to the vineyard because on record, based on the prior owner's report, he said it was around 4 acres. That's what we went with. I think it's been proven that it's 2.8, and we're not arguing that at all. Thank you.
Do you have a difference in value for the 4 versus the 2.8?
Yeah, I mean, we use 10,000 an acre for an improved vineyard. You're talking 15 grand. We put 40,000 on the vineyard at the change in ownership. That was how we allocated. We allocated land 847, the improvements at 1.263 million, and then the tree and vine at 40,000. So it would drop at 15, 20 grand but we'd put that value elsewhere in the allocation. To the improvement or to the land value, because again, we went ahead and inputted, he was assessed at what he reported to have paid for the property. Now, I understand that there's been misrepresentation, but again, our records show 2,000 barn. I don't know I think a lot of this report and what he's pointed out in his PowerPoint presentation is based on a projected as if renovated piece of property. I think as is condition, it's been shown a couple times in the report that what he paid was market value for the property, as is.
And I'm sorry, did you say that you reduced his assessment by the 120?
No,
you only reduced it by
No, we reduced it by 25,000 because he included personal property that was included in the 2.175 million that he reported to have paid for it, and we backed that out.
And so you didn't take off the 120 because you didn't value it as
No, that 120 was after the fact.
Right.
He bought it back in 2014. I don't know when he settled with these folks, but we had none of that information at the time.
All right. Very good. Thank you.
May I respond to some of this?
Sure.
Okay. So a few different points. One is that actually the appraiser did not have access or get the information in terms of that tree vine report from the county. So his estimate, and he, as you look through this report in terms of the vineyard, he basically said from the start, it wasn't part of our business plan, so we're not going to count that as an income producing aspect. he had asked the owner, he didn't survey it or anything. He asked the owner, who I think told him about the 4 acres. So we looked at that as, oh, it must be that this, because it was disregarded, that this must have been some error that was made because it was basically being ignored anyway. So I think that, you know, if you go into a car dealership and you see that a car has been advertised as having a V8 engine, and you get home and you've got a V4 engine, I think that you'd be kind of upset. And I think that you didn't get what you paid for. And that's where we're coming from. We expected to get 6 acres of vineyard, and we ended up getting less than half that. I think that the $120,000 is an accurate assessment. It went through the court system. There were depositions. I think that this wasn't a nuisance lawsuit that was brought to them. They obviously saw these, you know, if this was a nuisance lawsuit, they would have said, here, we'll give you $10,000 and go away. This was $120,000. So I think that there's significance to that. The other aspect to this is what Derek mentioned is, you took the value of what I paid for the property and took that as the accepted value. But if the appraisal had come back and said, oh, you know, and had been correct and accurately described the barn with the proper square footage and had accurately described the house, it wouldn't have appraised. It would have appraised for about, let's see, almost 200.
$1,865,000.
Yeah, so less money. And then the assessor office would have gone, well, you paid $1,865,000 for it. That's what we're going to assess you for. They're just taking the values that were from the sale price.
Can I respond to that? That's what we're supposed to do, is determine fair market value.
That's actually what's in the code.
But I'd like to point out too that, you know, what I've been giving you guys is the listing, and they were asking $2.25 for it. You guys settled on something less. And I also want to just say quickly that, you know, the vine reports, which I've provided you guys in Exhibit A, the first we learned of this vineyard was in '03, and we didn't even value it. The guy reported 2 acres, and we said, hobby farm, forget it. It's not worth the assessment. And then again in 2011 is where we come up with, and I've highlighted the approximate 4 acres indicated by the owner at the time. So as I've stated earlier, we have no issue with making an adjustment to what we have on record and what's actually there, 2.8. So we can make an adjustment there.
Well, I think there's a big difference between what was advertised and what we expected of 6 acres versus half that acreage. Again, we're not privy to what you had on record or any of that and any kind of valuations. So again, you know, I think in terms of the valuation, if this appraisal had been done properly, there would have been a significant reduction in terms of the price that they came up with, and a significant reduction in terms of what we would have paid for the property.
I'd like to make another statement. You know, again, I agree, but I think it's important to understand that the majority of this report is projection. It's as if renovated, this would be the value if it was a 5-bedroom B&B with, you know, they don't even discuss the vineyard. But that would include the renovation and converting the barn to these B&B, these rooms, and the basement area. I think it's important to take a look at the last page, the sales comparison approach. I don't see anything that talks about, I mean, you can see the subject is twice as large as any of the sales comps they utilize. So, you know, again, the building size, they're just giving overall building size. But again, I think it's important to state too, in the PowerPoint, the cost approach was utilized as if renovated. So those figures are a projection, again, not reality.
And I will counter with, if you look at these comps, you've got to look at it somewhat with a grain of salt. They're looking at properties in Healdsburg. I don't know if anybody's done a cost comparison between Cloverdale and Healdsburg or Yorkville. A little bit different. So.
Any questions?
No, I'm
Nope.
I'm good.
Okay. Then we will adjourn to private session. It's 11. Appeals Board hearing at 11:45 a.m. And we have made a decision on the, I'll just give Cookson and Whitney appeal. We have been restricted somewhat in that we didn't get assessment, the comp sale numbers from the assessor, so we had to go off of what we had that was put into evidence. So we are leaving the land at 859,917, changing the structures from 1,324,901 to 1,150,901, leaving the personal property at 17,682, putting the $7,000 exemption in, homeowner exemption, and the final assessed value then $2,021,500. Okay.
Okay.
Any other business? Where do we go to this thing?
Are we gonna have a?
We have other business, approval of minutes of July 16th meeting.
Vote on that?
Yeah, I think,
We
so
need to
I'll make a
vote.
motion to accept the assessment.
Oh, I'm sorry.
As Chairman Kramer just read.
Yes.
Second.
Okay.
Do you call it or do I? All in favor?
Aye.
Aye.
Motion carries unanimously.
Next business, approval of minutes, July 16th, 2018 meeting. Go ahead.
Move approval.
I have a motion.
Was I here?
I was not.
I think I was.
Well, I was.
Good.
I approve, or I second.
You can
it.
second, yeah.
I second it. I guess I can. Those who were there, all in favor?
Aye.
Aye. One abstention.
Motion carries.
Okay, we
And to-
open now the
and-
meeting to any public expression.
Sorry, and just a note before we move on, you can approve minutes even if you did not
Oh, I can?
attend.
Okay.
Yeah.
Great, thank you.
Any public expression? Go on. Any matters from the staff? Any announcements? The date of our next meeting, do we have a date?
The date of the next meeting is January 28th, 2019.
You gonna keep it?
Oh, yeah, thank you.
And a motion to adjourn? Do I need a motion or do I just adjourn?
I'll make a motion to adjourn.
Second.
All in favor?
Aye.
All opposed can remain.
Don't even say that. All right.